Look at the question as to whether or not legislative findings in the Voters First Act bills are sufficient. In reviewing recent legislation that proposes changes to California's Voters First Act, which was enacted by the voters by Proposition 11 in 2008, the same legislative finding and declaration is made in these bills. In my mind, it's a rather simplistic statement that raises a question whether this language meets the actual requirements of Prop 11. Now, Prop 11 enacted the Voters First Act, which was an initiative measure approved by the voters November 4th, 2008, and it requires the Citizens Redistricting Commission to draw district lines for the election of members of the legislature, Congress, and the Board of Equalization. Prop 11 first amended the California Constitution, and then it added numerous sections to the California Government Code. Section 4 of Prop 11 actually added Chapter 3.2, commencing with Section 8251, to Division 1, Title 2 of the Government Code. Now, of interest to us here is Government Code Section 8251, Subdivision C. It says that the legislature may not amend this chapter unless all of the following are met, and there are 5 requirements. By the same vote required for the adoption of the final set of maps, the commission recommends amendments to this chapter to carry out its purpose and intent. Second, that the exact language of the amendments provided by the commission is enacted as a statute approved by a 2/3 vote of each house of the legislature and signed by the governor. 3, that the bill containing the amendments provided by the commission is in print for 10 days before final passage by the legislature. 4th, that the amendments further the purposes of the act. And 5, that the amendments may not be passed by the legislature in a year ending in 0 or 1. As a result of this language, Prop 11 was a constitutional and statutory initiative enacted by the people, and it clearly allows the Act's statutory provisions that are contained in the Government Code to be amended by the legislature. The Act in Section 4 provides that any provision may be amended by a 2/3 vote so long as the 4 remaining requirements are met. Now, remember back Article 2, Section 10 of the California Constitution dealing with voting and direct democracy. In subdivision C of Section 10 of Article 2, it says the legislature may amend or repeal a referendum statute. The legislature may amend or repeal an initiative statute by another statute that becomes effective only when approved by the electors, unless the initiative statute permits amendment or repeal without the electors' approval. So this provision of the Constitution allows an initiative that was adopted by the state's voters to only be amended by the legislature, such as Prop 11 here, if that initiative permits an amendment without the electorate's approval. And of course, as we reviewed, Prop 11 does allow amendment by the legislature, assuming the 5 specified requirements are actually met. So the legislature may amend Prop 11, and they do so by adding what's called a plus section, which can be found at the end of a bill that proposes to amend the Voters First Act. And it provides a legislative finding and declaration. And this is the example that I generally see. The legislature finds and declares that Section 1 of this bill furthers the purposes of the Voters First Act within the meaning of paragraph 4 of subdivision C of Section 8251 of the Government Code. The question to address here is whether the language in that example is sufficient, or if there should be some sort of an explanation why the legislature believes that Prop 11's stated purposes are being furthered by that proposed amendment. Now, where are those stated purposes of Prop 11? They're found in Section 2 of the Act. Section 2 is actually titled Findings and Purpose, and it says that the people of the state of California hereby make the following findings and declare their purpose in enacting this act as follows. A, under current law, California legislators draw their own political districts. Allowing politicians to draw their own districts is a serious conflict of interest that harms voters. That is why 99% of incumbent politicians are reelected in the districts they had drawn for themselves in the recent elections. And in subdivision B, it says that politicians draw districts that serve their interests, not those of their communities. For example, cities such as Long Beach, San Jose, and Fresno are divided into multiple oddly shaped districts to protect incumbent legislators. Voters in many communities have no political voice. Now, unfortunately, bills amending Prop 11 generally contain a simple statement, as I read before, and those statements do not in any way explain why the legislature actually believes that the proposed amendment furthers the purposes of the Voters First Act. Instead, the bill's plus section merely states the legislative finding and declaration without any further justification or explanation being provided. So, as with other bills that require legislative and findings and declarations, should those bills that propose amendments to Prop 11 include a reference to any of Prop 11's specified purposes? I believe that they should to withstand possible judicial scrutiny. This approach, providing a short explanation, is often taken with urgency clauses and special statute statements. In other words, if the courts examine the urgency clause or special statute findings, there's at least a short sentence or paragraph even that explains why the legislature has determined a particular bill needs an urgency clause or why the bill qualifies as a special statute rather than a general statute. So perhaps the bills that propose to amend Prop 11 should also provide some rationale for their proposed amendments, so that if the legislation were challenged in litigation, for example, the courts would have a basis for understanding why the legislature determined this bill made a proper amendment to Prop 11 and it furthered those purposes. So the legislature going forward should consider adding some explanatory language to their rather simplistic statement in Prop 11 amendment bills going forward.